Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice James Mielke and Justice Dalila Windler. We will be the panel for the 5 cases that we will be hearing today. Before we begin the argument in the first case, I do want to pause briefly to reflect on the legacy of our lost leader and friend, Chief Justice Ralph Gantz, who died on Monday morning. He was a tireless leader, energetic and dedicated to the cause of justice. Before he became chief and continuing even after he was chief, he chaired the Access to Justice Commission in furtherance of his dedication to ensuring that the system of justice is available to all who come before it. And of course, he also was focused keenly on making sure that those who come before the justice system would receive equal treatment in the courts, as evidenced by the report that he commissioned that was released just last week. As you are probably aware, the justices of the Supreme Judicial Court have directed that all courthouses across the Commonwealth will be closed tomorrow for a day of remembrance in honor of Chief Justice Gantz. But today we are open for business. Chief Justice Gantz would want it no other way. And I would just ask that we take just a moment to reflect on his legacy before we begin. Thank you. And with that, I will open our session by calling the first case. Let me get our list here. The first case is case number 2019 E1521, the Commonwealth versus Tara Martin. You may begin.
May it please the court, as I indicated earlier, my name is Joseph Dever and I represent the defendant in this matter, Tara Martin. As I'm sure the panel has seen from a review of the material submitted, there are in basic form, I think, 3 issues that have been presented. I think I'd like to address them, I think, in the order of the difficulty in which I'm asking the court to act on Ms. Martin's behalf. The first issue that is, of course, presented is the constitutionality of the Massachusetts primary caretaker statute, chapter 279, section 6B. That's a statute that was adopted as part of a Criminal Justice Reform Act a few years, I think it was 2016. I'm sorry if that's not the correct date, but it was in effect an attempt to identify a important or a legitimate state interest, and that was the separation of young children from their caretakers, either parents or guardians or whomever, people that are responsible for raising children and forming bonds with children.
Counsel, if I can interrupt you, I'm wondering, did you find any legislative history that said that?
I believe I did, and I believe that's cited in my brief as well. That I don't have it exactly in front of me, but I think there was some extensive legislative history that was cited therein, and I think it was cited in the motion that I filed in the Lynn District.
Mr. Dever, you're aware that the Commonwealth has conceded that the trial court judge erred in ruling that the statute is unconstitutional.
Yes, yes, Chief Justice.
And I understand that we are obliged to conduct an independent review of that concession, but I, speaking for myself, have no particular questions that I need to direct to you on that topic. I can't speak for panel members.
If that's the case, if the rest of the panel have no other questions on that issue, And it is true that the Commonwealth has conceded on that issue that there is legitimate state interest that's furthered by a scheme that's rationally related to that interest, and there's no impermissible classification that's been committed. I would move on to the other issues unless there's some other question from another panel member on that issue.
Well, and then I guess moving forward, your second argument goes to the suggestion that the sentencing judge impermissibly considered certain factors in the imposing sentence, and if we adopt the Commonwealth's concession, the disposition would be a remand for resentencing, and wouldn't that obviate the need to address the questions of how the judge assessed sentencing the last time around?
Possibly with the second issue that I raised, that the judge, that there's this argument that the judge considered conduct for which the defendant had been committed. The judge, in many instances, several times, did note on the record that that he was not sentencing the defendant for operating under the influence, which she had been.
Counsel, just as a follow-up question, if we vacate the sentence and send it back for resentencing, isn't that particular argument, meaning your second argument, moot?
I agree that it would be raised again in the district court, and the district court judge would have a opportunity to reconsider that. And I could make the same argument that although he didn't consider the OUI, that he did consider this serious bodily injury.
Right. So we really need not address the second argument if we remand it for resentencing. I realize that there is some continuing vitality to your third argument. So why don't we spend some time resolving that? Correct,
Chief Justice. The third argument, in sum, is that although there certainly was sufficient evidence to establish that the defendant would concede that there was sufficient evidence that her vehicle, or that she was driving, did strike a pedestrian, did strike the complaining witness in this case, Ms. Susan Testa. There does not appear to be any evidence in the record that she struck a vehicle, as the statute requires, another vehicle or other property. It appears that throughout the testimony that was given at trial, and even in the testimony that was summed up in her brief by my sister, that it all relates to the contact between Ms. Martin's vehicle and the complaining witness herself, not any property of hers.
There was evidence, wasn't there, of damage to the victim's vehicle?
There was evidence of damage to the victim's vehicle, but
isn't it a rather, if not compelling, certainly a permissible inference that damage, consistent with the damage to your client's vehicle and the circumstances and timing of everything else, that the two were causally related?
That's why, Chief, that this last issue is really requires an examination of what that evidence was. And there was certainly evidence that there was contact with Ms. Martin, and there was certainly evidence that there was damage to the vehicle, but nowhere was there evidence that those damages, the damage between Ms. Martin's vehicle and the complaining witness's vehicle, matched up. The Commonwealth called this accident reconstruction expert, who really did nothing as far as doing any scientific calculations or measurements, or measuring the dents on one car and the other and saying that they matched. All there was police officers that said, well, there was damage on both vehicles. What compounded.
I'm wondering why it's not a fair inference that what happened was that your client hit the victim, and that victim was propelled into her car, causing the dent in her car. Why is that not a fair inference?
Justice Wendland, if there were expert witness that said that was the case, that the damage on complaining witness's vehicle matched, the size and body weight or likely force that she would have been compelled, would have been.
Mr. Dever, even without an expert testimony, specifically tying that, making that connection to a scientific certainty, the circumstances of this case aren't exactly like the mailbox illustration that is often found in the standard trial judge instructions on the meaning of an inference. But this comes pretty close to that. At least I'm just, again, commenting for myself. I can't speak for the other members of the panel.
Again, the statute itself, leaving the scene after causing property damage makes it clear that the damage has to be, first it has to be knowingly made, that there would have been some sort of sound, that there was a collision that might be different in kind than the sound if it was a person. I don't think that's a fair, I think there's under
Lattimore, we're talking about permissible, not necessary inferences, right?
Yes, absolutely, Chief. In this case, though, what makes it even worse is that the expert that the Commonwealth did call really did nothing that an expert would have done or should have done.
Well, even if the Commonwealth hadn't called an expert, again, I think a lay person in these circumstances, it seems to me, could very rationally infer that the damage to the vehicle was caused by your client's vehicle, which was located a short distance away, still warm, with damage on the side of the vehicle that was consistent with the damage to the victim's vehicle. I realize that we don't have video, we don't have scientific certainty, but again, we're talking about a permissible inference.
Well, there's also a time lag as well that and again, I'm not saying, certainly I'm not saying it's that it's necessarily the most likely way that it happened. It's a possible way that would happen. And what's the problematic here is that the trial judge in this case, instead of exercising that gatekeeper obligation and responsibility that the judge has in expert witness testimony, instead let the expert testify basically as to nothing, and then did not limit in any way to the jury, the finder of fact, as to what it was that the expert could testify to or didn't testify to. The jury was left with the impression that this was an accident reconstruction specialist, that he had done with specialized knowledge and training and with special tools and abilities to share information as to causation with the jury. And instead they were left just with his testimony alone and no instruction from the judge as to what
Also address the Commonwealth's argument that the objected to testimony really goes to the acquitted conduct.
Well, the acquitted conduct, and this is what's related to my second argument that I conceded we can move on to. The acquitted conduct is not just the OUI. The acquitted conduct is the serious bodily injury,
But serious bodily injury also is. I mean, we're talking about property damage. That was the crime.
That's the problem. We have this a plausible, obviously, argument that the damage here was the bodily injury, not the bodily injury. That it's probably more likely that the Commonwealth has proven, even though the jury acquitted her of this conduct, because there was blood, I think, on the car. I think there was a strand of hair not on my client's car, but on the complaining witness's car. So clearly at some point she had contact with her car. Whether or not the Commonwealth has proven that it was the result of the collision that between the defendant's car and the complaining witness is really not an answered question. And
that sounds like an argument that goes to the weight of the evidence, and certainly would be fair game for argument in closing to the jury. But again, we're talking about Lattimore and sufficiency here.
If I guess the language of the statute itself requires that there be property damage either to the other driver's car or to other property.
Well, and there was property damage. The question was the connection between your client's conduct and that resulting damage. And that's a question of whether a rational fact finder can draw that inference.
And has the Commonwealth proven beyond a reasonable doubt that the defendant knew or should have known that there was that damage? And here, I think an examination of the record leads to the conclusion that it's just as likely that they could have found that there was another, that she didn't know that she had caused any property damage, and
her questions to the officers when they arrived to question her statement, is everyone okay? Doesn't reveal some awareness.
Well, I suppose that's the closest that they've come, but that's the closest that they've come.
Coupled with the physical evidence, the blonde hair attached to the vehicle, consistent with a involuntary contact between her head and the vehicle.
Again, it seems quite plausible that it's possible that the defendant knew that she may have struck Ms. Testa, but whether she knew that as a result of that striking Ms. Testa, that property damage has been caused, to me is something that bears legitimate inquiry and a careful review of the record.
I take it, counsel, that your client was not charged with leaving the scene of personal injury or whatever the precise statutory term is?
She was charged with OUI causing serious bodily injury, and that's what she was acquitted on.
All right. Unless there are further questions for the panel, I see that you have about 30 seconds left. If you have nothing further, we can hear from the Commonwealth.
I guess I would just the portions of the record that I've cited concerning this distinction between the serious bodily injury for which she was acquitted on, and the requirement that the property damage be knowing, and the lack of information in the record, and the influence of the expert witness's testimony, likely influence, makes it I think an important area of inquiry for the court. Thank you.
Thank you, Mr. Dever. And as I promised you, the red box is pretty evident. So
yes,
for the Commonwealth.
Good morning, may it please the court. We have, as the court noted, conceded that Judge Nestor was in error when saying that the primary caretaker statute violates equal protection. The only thing I would add is it was the Commonwealth's position, certainly, that if this court, as I expect it will, remands it to the trial court, that it would be appropriate to remand it for reconsideration of the motion to revise and revoke specifically. The primary caretaker statute was first raised by the defense in a motion to revise and revoke. It was not raised at sentencing. In fact, it was raised outside of the 10-day period in which it is supposed to be raised, which was not an issue that either party addressed. So to bring it back to where it belongs, I would suggest would be to bring it back to the motion to revise and revoke, and let the defendant present his full argument, and the Commonwealth will as well.
Why does that subtlety matter?
I don't know that it practically matters, but I don't think that there's a need for the court to conduct a full resentencing. And I suppose it may matter in the sense that the defendant did bring up the caretaker statute late, so the court may want to consider that in determining whether the statute has really been triggered. And it seems like that's most appropriate in the motion to revise and revoke, which was what was ruled upon in this case.
So, sorry, go ahead.
No.
So what you're saying is the Commonwealth might like the opportunity to argue that this motion is too late.
Correct, Your Honor, yes.
And that argument you think is not waived?
I'm not sure if it's waived. I mean, that the trial court could certainly consider it waived. if we raise it in regard to the motion to revise and revoke. But I do think that we should have that opportunity. The judge did, interpose his decision about the equal protection clause. I don't think either party then really presented their full argument because that pretty much cut it off after the judge had determined that she was in fact a primary caretaker. The judge very well might find it waived, but I do think that's the appropriate posture.
Are there ramifications from this point for how we handle the second argument? As you heard in our discussion with your brother, it would be moot if the judge resentences and is able to consider any arguments based on this and explain the ruling or the sentence. If you're saying you reserve the right to argue that the caretaker issue is waived, do we then have to reach the second argument in this appeal?
If the court remands it for resentencing, then no, I don't believe you need to reach the second issue in the case. If the court remands it for reconsideration of the motion to revise and revoke, then I think the issue is probably properly before the court. So it would depend on what the court feels is the correct remedy in this case.
Of course, in order to remand, we would have to agree with you on the third issue.
Correct, Your Honor, which I would be happy to address. I think the bottom line, and I'm just going to interject and apologize for my shadowy face, which I don't seem to be able to fix. So sorry for that.
As a rather experienced Zoom user, I can comment that that having the windows behind you risks creating a silhouette. If you turn the orientation around for the next time, it may work a little better.
All right, thank you. I appreciate that.
So tell me why Bergeron's testimony was permissible. It as I think the chief indicated before, it doesn't require expert testimony to infer. What happened here was that the defendant hit the victim and the victim hit the car.
That's true. I don't think it's necessary at all.
Why is it permissible, given that it's not necessary?
Because it's not necessary in a general sense in that the jury could have inferred, but the things that the trooper brought to the table were beyond the common knowledge of laypersons. He examined the roadway for any defects. He examined the neighborhood to determine what the traffic patterns were and drew inferences from that. He eventually drove both cars, so that was a slightly separate issue, but he determined that there were no, mechanical problems with either cars. And the defense certainly never objected to his testimony in any general sense.
How do you respond to your brother's argument regarding the defendant's knowledge?
I'm sorry, which part of his argument?
That the defendant was aware that property damage had resulted.
I think that knowledge is very often, reliant on inferences by juries.
So I understand, but what we had was we had no testimony regarding the sound that would have resulted from the impact that was observed, right?
That's true.
My question, as you heard to your brother, really talked about her comment about a person, not property. Yes,
and I do think that comment that Your Honor pointed out was important to demonstrate that she had some awareness that something had happened. But I do think that jurors in this instance can draw on their own common experience of having, unfortunately, most of us struck something at some point with our car. And here we saw that this was a fairly dramatic collision. The victim was seriously hurt. The mirror was broken. There were dents on both cars. The victim's blood was on the defendant's car. And so in order for the jury to infer knowledge, I I don't think that you need expert testimony. I think that jurors, based on their own common experience, can draw a conclusion as to whether someone who was involved in that accident would likely have known that something happened.
Any
Nothing
light
happened.
you can shed on why the Commonwealth did not charge leaving the scene of an accident that caused personal injury? Seems like the Commonwealth went to the jury with one hand tied behind its back.
I think that is true. I'm not sure why we didn't. I know that it was discussed at trial, as you know, it was perhaps an oversight on our part, or perhaps we were just focused on the OUI as serious bodily injury, which certainly would have encompassed that. It did leave us without a lesser offense. Well, it's not a lesser offense, I guess is the problem. And it did leave us without that option for the jury of not having found her OUI, which was a problem that was seriously challenged by the defense in this case, but still finding her directly responsible for the injury to the victim. And
stupid question I should know the answer to, but I take it that the damage to the defendant's own car does not count for purposes of the leaving the scene.
Correct. I think I'm looking at the elements here, that the defendant must have operated a motor vehicle and collided with or caused injury to another vehicle or property. So yeah, so that is important. It does need to be the other vehicle. And I would certainly suggest under the Lattimore standard, there was ample evidence in this case. There was no request to have a voir dire of Trooper Bergeron. The defendant, in fact, used Trooper Bergeron as much as their witness as ours. It's a very lengthy cross-examination, really detailing a whole host of things that they felt like the police or the investigation did not encompass. But at the same time, it is not like the Commonwealth produced a witness who said nothing that required any knowledge or training, which he clearly had. There were, as I outlined, several ways in which Trooper Bergeron examined the area and drew conclusions from it that were necessary or at least helpful for the jury. Are there any further questions? I'd be happy to address any of the arguments.
If you have nothing more for us, we can move on to the next case.
If I could, just a moment, Your Honor, I would just like to share also our condolences from Essex with regard to the passing of your colleague, Chief Justice Gantz. And I think that the way he performed his role made us in the bar as well feel that we were all colleagues in a common pursuit here. And it was very special, his tenure, and I know he'll be missed by all of us. Thank you.
Thank you. Okay, we will move to the waiting room and greet the counsel in the next case. Thank you both.
Thank you.
We are live and on the record.
Okay, continuing with our session, I will just note for the record that as I opened the session for this morning's argument, I offered some comments in memory of Chief Justice Gantz. I will not repeat those here. Anyone who is interested, I can refer back to the YouTube archive. But we all lost a great friend and leader earlier this week, and we will carry on in his memory. The next case is case number 2019 P782, the Commonwealth versus Cody F. Tuamala, and I apologize if I've mangled the pronunciation.
It's fine. Good morning, Chief Justice, members of the panel. My name is Molly Ryan Strehorn, and I represent Cody Tuamala. This case is before you on issues. The trial court did not have jurisdiction over an invalid complaint and insufficiency of the evidence. I would like to start first with the invalid complaint. Personally, this has been one of my favorite issues to research and write about and think about, and I think it's because it brings me back to what I first learned in law school. Jurisdiction is central to our ordered concept of liberty. And the complaint is really the backbone of jurisdiction. The elements are essential for a person to understand what they have been charged with, and a plain, concise description is absolutely fundamental. As you could see,
Counsel, can I just interrupt you because time is short? To some extent, you appear to be conflating two different notice issues. One is the fact that at the time of this trial, no one had any idea what the elements of this crime were, with the separate issue of was the complaint on its face adequate, assuming you knew what the elements were. And on the first issue, was this in effect cured by the Rule 25 motion? Don't appear to be arguing that because the judge the first time around resolved this case prior to Adams, that there had to be a new trial and it had to go before a different judge. There seems to be some acquiescence that this would go back to this judge for the judge to refine the facts based on his correct understanding of what the law is.
Well, I have split those up into sufficiency of the evidence and the validity of the complaint.
No, but sufficiency is a different issue.
Correct.
Had there been no Rule 25 motion, you very well could be arguing now it's clear the judge did not instruct himself correctly on the law because no one had any idea, as the Commonwealth conceded, what the elements of the crime were. Therefore, new trial, new judge, let's have a do-over. That argument doesn't appear to be before us. Would you agree with that, just to start with?
Correct, Your Honor, yes.
Okay.
It appears that what the judge did was he conformed the complaint to the facts presented, because at the time of the trial, there were no elements. And so he just took the facts and fit them into what he believed could be the elements based on a very vague complaint.
Okay, but let's assume, for the sake of argument, that Adams came out 2 months before the complaint, rather than 2 months after the trial.
Okay.
With that as the working assumption, how was the drafting of the complaint on its face invalid?
So if it had come out 2 months before, then the complaint would have had all four of those elements. It would have had the first most important one, which was to have the intent element, and then the second one of the clarification that it must be a physical act. So
Okay,
if you
but as a counsel, as a general matter, I mean, keep in mind, Palladino is now a half a century old, believe it or not. As a general matter, the SJC has made it fairly clear you don't necessarily have to plead specific elements in order to have a valid complaint. The issue is, generally speaking, one of fair notice to the defendant. I take it your strongest argument is based on Palladino itself. Is that a fair statement?
Correct. Yes. I mean, without the elements of intent and a physical act, the defendant wasn't able to craft any sort of strategic defense, which is absolutely prejudicial. And
but had Adams come out before the complaint was issued, wouldn't your client have had fair notice of what he was being charged with?
Well, if then the complaint followed the elements of Adams, but just like in Palladino, the Palladino followed the statute, which was actually not constitutionally sound. The inadequacies had to be corrected prior to that. And because they weren't corrected in the statute, then when the complaint tracked the statute, it was unconstitutional without that element of intent. So under your hypothetical, Adams comes out, the entire complaint process starts tracking the elements that were explained in Adams, then yes, the defense would have had the ability to craft a appropriate defense based on the knowledge of the elements. Then the judge, the trial attorney, and the ADA would all know
Can
the
I stop
elements.
you, counsel? Are you in this new hypothetical? Adams comes out. Are you saying the complaint tracks Adams, or
No,
is
no.
the complaint that we currently have?
This hypothetical complaint. So if we have Adams, which has outlined what the elements are, and then the complaint tracks the Adams elements.
No, but stop you there. What if the complaint is the same as the complaint that's here?
Then
That
it's
it doesn't have the 4 elements expressly spelled out.
right. Then it's an invalid complaint. Which
Why?
Why?
Since
It-
since counsel would have known what the elements are.
Right.
And faced with an allegation of the interference with the police on a particular day, why wouldn't that be enough for fair notice?
Well, if so a complaint has to have these necessary ingredients. It's almost like baking a cake and you leave out the sugar. So you need to have in the complaint all of these necessary elements.
No, you don't have to have all of the elements. That part is clear. You have to have the conduct, and if the elements are fairly described in the law, then the description of the conduct attaches to those elements without the need to recite them specifically in the complaint.
You have to have the essential elements, and if you have an obvious element like in charging possession of a firearm, you don't have to say that the person knew that it was a gun. But in this case, there was no element of intent. So you have no distinction between a constitutionally protected First Amendment right and something that has been criminalized. Very similar.
Let me just, if I may, take you back a half a step, so that I can understand the scope of what you are asking for here. You are contending that that because the complaint pre-Adams did not fairly apprise the defendant of the crime, that the court was without, the complaint did not confer jurisdiction on the court. That renders the conviction void, right?
Correct.
And that would be true as well for all other criminal complaints and convictions pre-Adams.
You're probably referencing the 2,600 that were
all of them in history. I don't think we have to go back to 1634, but it would mean that any criminal complaint, by definition, before Adams defined what the elements are, would be inadequate to confer jurisdiction on the court, rendering all of those convictions void. Is that your contention?
Well, Your Honor, I not to be cheeky, but I don't represent all of those other cases.
I am simply asking you a question, and if you have an answer, I would like to hear it.
I would like to say, I don't know if in any of those other trials, the judge, the district attorney, and the trial attorney could not identify any essential elements. I don't know if any of those other
We're not
judges.
talking about in the trial or what the judge was doing. We're talking of your argument goes to the face of the complaint. And I suppose it is conceivable that someone either unwittingly or presciently would have anticipated Adams and laid out those elements in the complaint. But color me skeptical on that proposition. And certainly, I think we can assume without a great deal of inquiry that there will be a not insubstantial number of cases that would fall into that category. I'm just asking, your suggestion would be that when the Supreme Judicial Court decided Adams, it recognized, as it must, right, that it was post hoc invalidating all prior criminal convictions because of the inadequacy of those complaints.
Then I would say yes. I would say on its face.
I thought that's what you were arguing, and I just wanted to hear it explicitly. Thank you.
Yeah, counsel, its time is getting very short. If we can turn to the merits. In Adams, the court recognized that a verbal threat is enough. And that's one exception to the need for action, if you will. Why couldn't the fact finder, looking at someone standing directly next to the police, be it 1 foot or 2 feet, yelling, "Get the fuck off him," interpret that as an implicit threat, as if the person were saying, "Get the fuck off him, or else I will do X."
Under a hypothetical situation, if there was testimony from those officers that they felt threatened or that there was an explicit threat, and in this hypothetical where the fact finder and both attorneys know that a threat is a way to prove that element, then under those circumstances, there could be evidence that meets the facts. But there was no testimony in this case that there was anything other than annoyance. I mean, the officers clearly said that they felt distracted, that they felt that he was.
So can I stop you there? Now, is that verbal threat? Are you suggesting that's a subjective test? That if the officer does not feel threatened, then no go on that element, or is it an objective test?
I think there would have to be something factually explicit in the trial because of the way that the Adams elements were crafted. There was a physical act.
Can I, just because we are running short on time, that sounds like you're suggesting that's subjective.
I'm suggesting that because the First Amendment is implicated under the case law that Adams wove through, was that it has to be evidence that the officers felt threatened. So there would have to be evidence of it to meet that element.
Subjective test.
Yes.
Okay.
Any other questions on that piece?
Well, why couldn't the fact finder on the testimony that was given here conclude that when the police officers were talking about the distraction, which was the need to pay attention to this person screaming in their ear, that they were concerned about their safety? In fact, I think there's other evidence that they said that they were concerned that they may not have used the exact language, potential threat, but that is the sense that I think can be derived from what they did say.
Well, I think what Adams really made clear was that when you have constitutionally protected speech, it needs to be very explicit. When they discussed other statutes from other states that have attempted to criminalize this type of conduct, officers get this type of yelling or negative response in a lot of different types of situations. And as the court said, because this could come up in many different cases, we have to be very clear about the type of conduct which is criminalized so that it doesn't intrude on constitutionally protected activities. I see that my time is running out. I have appreciated the questions, but I would just like to close with this case is really, and under the two issues, the jurisdiction is very important and the sufficiency of evidence is very important. If the defense, the ADA, and the judge didn't know the elements, then there was such a prejudice that we cannot have jurisdiction. And under the sufficiency of the evidence, without the benefit of going through the elements, there was no evidence to support this conviction. Thank you for your questions.
Thank you. For the Commonwealth.
Thank you, Your Honors. May it please the court, ADA Johanna Black for the Commonwealth. I will start with the sufficiency of the evidence argument. In context of the Adams decision and the 4 elements that it enumerated or clarified, I would say, The evidence against the defendant in this case, as testified to by the two officers, was sufficient. The officers, as Justice Milkey referred to, testified to not only was the defendant yelling obscenities and telling the officers to get the F off of the person they were trying to arrest, he also was right up on them, as they described him, in their face is a reasonable inference.
Yeah, counsel, can I interrupt you there? So it's not so much that he was saying get the F off of him. He was coming at the officers. That's the physical act. Isn't that the Commonwealth's position?
Exactly, it's part of it.
Not
And as
his
Justice
language, not the verbal words coming out of his mouth, but that he just kept coming at them while they're trying to apprehend somebody else, and they're telling him stand back, and he's not doing it. That's the physical act.
Right. So the physical acts are the coming at the officers, the not stepping back, and the being on top of them. But as Justice Milkey referred to, the acts, the physical acts combined with his words, I apologize, I just interrupted, were threatening in nature to the officers. And I think it was Officer Machado who testified to that effect.
Where's the testimony that he was quote unquote coming at them? As I read the trial transcript, the third party who was screaming was in the street, and the officers moved him over to the side of the street where the defendant was standing. It wasn't that this guy was coming at the officers. He was certainly close to them and refused to leave, but that paints a very different picture.
So I think coming at the officers is a reasonable inference from I think it was Officer Aronson's testimony on page 9 of the transcript, where he's saying the defendant kept approaching the officers as they arrested this individual, yelling at them. So that the continuous approaching the officers while yelling, I think that evidence is sufficient. It's a reasonable inference from that evidence is that he is kind of going at the officers, especially when you take it in conjunction with their testimony on page 8. The officer, I believe it was Aronson again, his testimony on page 8 that about the defendant being right up on top of us, right on top of us was his language. I think it's significant that the judge actually wanted to put on the record the gestures the officer was making and that were repeated or demonstrated by the prosecutor in closing.
But in that same statement, didn't the judge then clarify that he accepted the testimony that there was up to a 2 feet separation?
So I think I understood it as he definitely accepted that the officer on cross-examination agreed with the defense attorney that he was within a couple feet. I'm not sure which conclusion the judge actually ended up making, whether it was 1 foot or 2 feet. But if you think about 2 feet and you think about someone yelling within 2 feet of you, that is right up on you. That is in your face, in your personal space. So to me, that is, to the Commonwealth, that is coming at you. I think that evidence.
I want to just again take a half a step back and make sure I understand the way that this case lines up. If we agree with you on the jurisdictional argument, but disagree with you on the sufficiency argument, the defendant, the conviction would be vacated. The defendant may not be retried. Correct?
Correct.
If we disagree with you on the jurisdictional question, then the sufficiency is immaterial. You could bring a new complaint and retry the defendant. Correct?
So
jeopardy would not have attached if there was no jurisdiction.
Jeopardy would not attach to no jurisdiction. That's actually I agree with that logic. I can't say that I came up with that on my own. You saying that though is very reasonable.
I try.
I think I'd have to look further into it, and I'd be happy to write a 16L letter.
No, not necessary. I'm just trying to puzzle out sort of what this all means.
Sure. I do think it's significant that the defendant was tried. It's not like a pretrial posture, as your honors are aware. But I also think it's significant it's the defendant here who's moving for dismissal and not the Commonwealth who null prossed or moved for dismissal during trial or thereafter.
Again, maybe there's some case law out there that suggests that that jeopardy attaches even in the absence of jurisdiction, but I frankly would be surprised to see that.
Right. So,
Counsel, how is there jurisdiction, given that nobody seemed to know what the elements are?
so I disagree a little bit with that. I think that the prosecutor did state what the common law was at the time. She didn't explicitly say, I don't know what the elements are. She understood that there were no, right. Well, I think she was agreeing with the fact that there are no elements specifically enumerated. There's no statute that lists them. There's no jury instruction. There wasn't a case that was like Adams today.
Right, and so that's my question here. Given that there was no guidance and nobody knew what the elements were, certainly in the trial, how is this fair notice to the defendant?
Well, I think there was guidance. As the SJC showed, there was common law and different sources that lawyers can look to understand the charge. And I think the judge actually
as I understood the SJC decision, the review of the common law and even the instruction here on the complaint manual and how to form it was really to sort of get a baseline. Yes, this is a crime. And then to look at what the elements were, I thought the SJC looked at Minnesota law and said, that makes sense. That is consistent with the First Amendment. So how would this defendant know that Minnesota law was where to go to find out what the elements were?
Well, I think the court was clarifying again. I think First Amendment protection has been in existence, and that is an area of law that is accessible to attorneys, to the defendant's attorney prior to trial. Speech
counsel,
is protected, and that, sorry.
where did the Commonwealth acknowledge at trial that it had a duty to prove specific intent?
I'm not sure that I don't remember that issue actually even coming up. So
precisely.
Right. Well, I think it was assumed. I think
assumed by whom? The judge certainly didn't assume it, as his explained rulings both before and after Adams demonstrate.
Well, I think that the judge understood the essence of the crime of interference with the police officer, which is essentially a defendant is interfering, hindering, obstructing a police officer who's engaged in the lawful execution of his duty. And the judge, one, was saying, with respect to the First Amendment concern, he's not going to rely on the words of the defendant, the content of the words of the defendant, what he actually said. It's more about his conduct, how he expressed himself via demeanor and actions, conduct, acts, physical acts. I think when the prosecutor was saying, the defendant was aware of what he shouldn't be doing, that he knew he shouldn't be doing this, and the judge was accepting that in their discussion, I think that implies that he knew the intent was required. There is a guilty mind.
Counsel, say hypothetically we don't agree with you on this. Isn't the real problem that the trial judge resolved this case while not properly instructing himself because Adams hadn't come out, in which case the proper remedy might be a new trial? I realize that defense counsel has phrased this argument in terms of the adequacy of the complaint, but it strikes me that there may be a separate problem in terms of just the fairness of the trial.
So I'm just looking at my notes very briefly.
Stated another way, I think Judge Milkey's question is whether we would apply the ordinary presumption that the judge correctly instructed himself on the law in circumstances where the law had not developed at the time of the trial.
So I think you can. I do think I'm just trying to find the judge's words.
It's a pretty interesting abstraction, isn't it?
Well, It always is interesting with bench trials, trying to figure out if that assumption should
No,
apply.
but
or not.
I think in the circumstances where the law did not exist, I'm trying to think just from an epistemological perspective, what it means for the judge to correctly instruct himself on something that doesn't exist.
Well, I think there was law that he could look to. So I think there was some law that existed. So for example, the judge felt strongly that the defendant was intimidating the officers. He says that in their discussions. And an intent to interfere is part of intimidation of a witness. It's implicit in the legal definition of intimidation is intention. Wrongfully using violence to or intimidating another person with a view to compel him or her to abstain from doing or to do any act which he has a legal right to do. And the judge found that the defendant was intimidating the officers, and he thought that that was sufficient under the crime of interfering with a police officer. So to me, he was thinking beyond what he may have explicitly been saying. If he's looking to the intimidation, he's thinking about the threat of violence, that it's not just protected speech that the defendant was engaging in, and he's thinking about what were the defendant's intentions. So I don't think it's a scenario where he had no guidance and that that it was obvious that he misinstructed himself. And I also think it's significant that he was the finder of fact and that he was thereafter provided with Adams with the enumerated elements.
Okay, I want to touch on that. Are you aware of any case where an appellate court has concluded that there was an error in a judge instructing himself or herself, and that the remedy for that was not a new trial but a remand to the trial judge to apply, to re-review the evidence and see whether or not a guilty verdict was appropriate?
I don't know of one off the top of my head, but I do think the scenario is unique in that he was the trial judge, he was the finder of fact, the assessor of credibility, and he reviewed the transcript. I also know that.
Don't we also have to take into consideration not only that the trial judge didn't know the elements, but that the defendant might have chosen a different trial strategy had he known?
So the defense, at least as far as I recall, hasn't provided an explanation as to how the defense would have changed. So I don't see any evidence of confusion, or, the attorney was saying, there aren't any elements to follow, there's no jury instruction. But in terms of the actual practice and what actually went on at trial, I don't see, and in the brief, I don't see any evidence of how the defense would have been any different.
Okay, let me just turning back to the merits. The SJC has said you have to, interfere. Here, the third party was successfully arrested. Why? How is that? How did our defendant interfere with something where, they may have been mentally distracted, but the reality is Sorensen proceeded apace to arrest the third party?
Well, I don't think the crime requires that the duty is not accomplished. I think where it uses the words hinder, interrupt, interfere, delay, slow, make more difficult are sufficient. And I think
make more difficult. Where does that come from?
Well, I think just that's kind of the common understanding of hindering or interfering.
Why aren't those words? I realize we're interpreting words from the SJC and not from a statute, but why aren't those words at least somewhat ambiguous in terms of whether or not one has to actually cause an adverse effect as opposed to potentially? Or put it differently, why isn't this at most an attempt to interfere as opposed to actual interference?
Well, I think if you do look at the totality of circumstances in the evidence, he did actually delay the officers. It took them time to get the party they were arresting off the street. The officers had to take the time to repeatedly tell the defendant to get back to step back and step away. So I think he did succeed in interfering. The language isn't make impossible or not allow or stop or destroy the ability to complete or perform the act, the lawful duty.
I see. I see that your time has come to an end. I think we'll leave it there and
Okay.
return you to the waiting room and move forward with the next case.
We are live and on the record.
Okay, we are back on the record. I will again note that at the opening of the session this morning, I offered some comments in remembrance of Chief Justice Gantz. I will not repeat those here. We do honor his legacy by continuing with our session today, and we will observe the Day of Remembrance as directed by the Supreme Judicial Court tomorrow. Our next case on this morning's list is case number 2019 P 1727, the Commonwealth versus Daniel Rodriguez. You may proceed.
Thank you, Your Honor. Suzanne Renaud for Daniel Rodriguez. Your Honor, this is a matter of probation revocation and the sentence from that. And he was noticed for several different allegations, some of which were criminal and some which were non-criminal, and he was revoked on all bases. And I wanted to start off actually with the non-criminal violations, if I could very briefly. And the reason for this is because I think that they are sometimes looked at as an afterthought, and they shouldn't be. Because if they're part of the notice and if they're thought of as being important enough to revoke somebody's probation and to sentence them on or increase the sentence, then they deserve just as much consideration as the alleged criminal offenses. And in this case, one of the problems, it appears, is that they were not taken as they were. Doesn't appear that they were looked at as scrupulously as the criminal matters, because of the 4 non-criminal bases that were alleged, 3 of them did not have sufficient evidence. In fact, on the restitution issue, which was the only one that was sort of developed during that part of the hearing, the probation officer admitted straight out that he had no information about whether Mr. Rodriguez had paid the restitution, whether any was still owed, whether he was on some kind of schedule, whether it was owed at the end of his probation period. He had no information. In fact, this matter was supposed to.
Can I stop you? It sounds like you're conceding that at least one of the non-technical, one of the technical ones had sufficient evidence. Which was that? That
was that he missed a meeting with his probation officer, Your Honor.
Okay.
So
you call that a technical violation, but that's a pretty big deal, isn't it?
Well, Your Honor, I think I called them a non-criminal violation. I've been trying not to use the word technical violation. Is it a big deal? Certainly, it could be a big deal. And I am not saying that he did not meet that standard. That is the one where I will concede that he missed those meetings. But here we have 3 other non-criminal and then 3 alleged criminal violations, all of which sort of add up. So,
I want to just pause for a moment as we proceed down the specific violations to make sure that we have a common understanding of the framework and the effect of what we're talking about. Because of course, if any one of the violations alleged is proven, the judge may revoke probation. But for our disposition of this appeal, if any is shown to be unproved, we may not affirm the revocation of probation without knowing what the judge would have done. And so if any is unproven, we have to return the case to the judge for a reconsideration of whether to revoke probation or not.
Yes, Your Honor.
Yes.
That is my understanding. And in this case, it isn't clear exactly what the basis was. And so the controlling law is that it has to be remanded for reconsideration altogether of whether or not it would be revoked and then resentencing potentially. So this is not an immaterial matter. So there is no proof here by a preponderance of the evidence of the restitution issue. On the question of random screens, there is not even an allegation of when he was ordered to appear for a random screen. There's an allegation of when he was supposed to appear to meet with his probation officer. But by definition, a random screen is supposed to be random and on a different date. And that's not even in the notice of what the dates are that he allegedly missed. So to revoke on that basis, I think is problematic. And then on the final one about the DNA, that was not even noticed until the day of the hearing, or I believe December 17th. And I acknowledge that I missed section 4 of the statute, but he was not alleged in the probation notice of having violated the laws of the Commonwealth by failing to comply with section 4. He was alleged to have not complied with a term of probation, which very specifically was to provide DNA and to comply with section 3, which has no mention of payment. So on that basis, he didn't violate his probation contract. And if you were to say he violated section 4, which was not brought up at the hearing, you could simply just look at the docket sheets here, which indicate that he is in fact indigent. So he is not a person who would owe money anyway, because he is indigent and he has assigned counsel. So those 3 non-criminal bases right there are reasons to remand this matter. So with that said, moving on the merits of the alleged criminal matters, what it appears to be is that obviously this has to be evaluated for abuse of discretion, although your honors can look at the documentary evidence de novo, and it's on to determine whether there's a preponderance of the evidence based on, in this case, it was all circumstantial evidence that it was Mr. Rodriguez who was the perpetrator of these 3 crimes. But the thing with circumstantial evidence, as you well know, is that it cannot be too speculative. And you have 3 different groups of evidence that were used against him, all of which have, for lack of a better term, inconvenient facts that make some of those inferences very speculative. And to start with the gold Toyota or tan Toyota that he was seen in, which had different license plates than when it was stolen, there was a person in the car who was engaged, who appeared to be overdosing on drugs. So to say that this stolen car with drug connection is necessarily connected to a robbery 3 weeks before, I think is really, that is again speculative. And the only tie in that car to these incidents was a bag somewhere in the car that contained an instrumentality of the crime, which did not have his fingerprint on it. It had the fingerprint of somebody else. So that type of fact really makes it so that particular, the mere fact that he was found in that Toyota does not indicate that he is the perpetrator of the crimes. And I understand that's not the only piece of evidence against him, but I would say that seriously weakens that connection with the gold Toyota. The next group has to do with the identification by the 3 different clerks at the 3 different stores, and none of whom identified a person who fit the description of Mr. Rodriguez, who's 5'9" and Hispanic. That's information that is on the record before you. 2 of the clerks identified somebody who was over 6 feet tall, and 2 of the clerks identified a black male. So, and when you look at that in connection, you don't have him meeting the descriptions. And those descriptions are also verified in part by the police officers who watched the videos, and the videos are before your honors as well. So 2 of the videos are before your honors as well. So that type of inference that it is him because he matched the description is already weakened. So that leaves you obviously with any things that are related to this black Honda automobile, a very common automobile, a very commonly stolen automobile. And he's seen in a black Honda 2 or 3 weeks after the PetroSafe break-in that did not have the same license plate. And we don't have the state trooper testifying about it, but he described something notable about that black Honda. He said that it had a popped ignition. He didn't mention anything about the rims. He didn't indicate in that particular report when these license plates were stolen, but there were 2 license plates that were stolen. And incidentally, they did not match what you can see on the video and what was reported by the police officer as the license plate of the black Honda at the PetroSafe. He also mentioned—
It doesn't take long to swap out a license plate, does it?
It might not, your honors, but we don't have any indication about when this stolen license plate was put on here. And I think that, sure, certainly stolen license plates, that's one factor. But I guess what my point here is that is a descriptive factor that doesn't match. So it is not, it's not weighing in favor of saying this is the same black automobile.
Well, I mean, we're dealing with preponderance here, not even, we're well accustomed to reviewing sufficiency under Lattimore. You have a steeper hill to climb here even than Lattimore.
I do understand that, Your Honor. But I guess I think the more significant fact here is the rims and the description of the rims, and that can be seen on video, which is no rims on one side, black rims on the other. Those are very distinctive features of the car that is involved in the Petrosafe break-in robbery. And that is not mentioned anywhere in the police report. The only evidence that the Commonwealth put in from the state trooper. So even if the license plate could be easily switched out, those kinds of descriptions of these vehicles cannot be easily switched out. And so I think that becomes more significant in making this connection, because what you have here are just weak connections. And yes, it is a preponderance standard, but so far all we have are weak connections. And the one thing that seemed to tip the scales here was the fact that Detective Schaff said, these are the same guy who's in this picture from the city camera is the person who I saw on the inmate web, which was Mr. Rodriguez.
Right.
And his lay opinion never should have been in evidence.
There was no objection to it. When we're testing sufficiency, we assess the evidence as it came in, right?
Well, Your Honors, I think you can assess you would assess that evidence for the weight that it would be, but that it would be.
When we are asked to assess the sufficiency of the evidence, we consider the evidence as it appeared before the trier of fact. And if there was improperly admitted evidence, that doesn't go to sufficiency. It may be grounds for a new trial on a typical. But there was no objection here, right?
There was no objection, but I think to the point.
So the judge was entitled to rely on the lay opinion, whether or not it should have been admitted, whether it could have been excluded on a proper objection. It is sufficient as a basis to support the conclusion.
Your Honor, I would say one very significant fact to this. The law has been clear for a while now that when a decision by the judge below is based on documentary evidence, Your Honors are entitled to review that particular piece de novo. So regardless of whether or not Detective Schaff's lay opinion should have come in or it should have been relied upon by this judge, this is a particular piece of evidence that you can look at on your own without relying on what the judge's conclusions were.
Well, I understand that, but our task on appeal is to review whether the evidence was sufficient to allow the judge to reach the conclusion. If the judge chose to credit that testimony, why is that in and of itself not enough to satisfy the sufficiency requirement?
Because, Your Honors, that is not the type of evidence where the judge's credibility determination should be weighing on your determination. Your determination should be to look at that piece de novo, not whether or not the judge was proper in crediting it or not crediting it.
So your contention is that we can, in these circumstances, review some evidence de novo, and on the basis of that, set aside a credibility determination by the judge on testimony?
Yes. Because it's not based on credibility.
Do you have a case that says that?
I think the two cases that I cited in the brief are saying that when it's documentary based, you can set it aside. I think maybe we're talking about two different things here.
I think we are talking about two different things when you're asking us to look at photographic or video evidence and to on that basis to set aside the judge's reliance on testimony he found credible.
Well, he found this credible because to be honest, his opinion, his decision didn't say that, his decision didn't say that I relied on it specifically. It appears what happened is that he agreed with Detective Schaff's opinion. And if he agreed with Detective Schaff's opinion or credited it, I suppose is another way of looking at it, regardless, you could disregard that particular piece because it's not really based on a credibility determination. It's based on a review of documents. And that is the reason why I'm suggesting that. It's not because his credibility determination is irrelevant here.
It seems to me that it would be one thing if the photograph with a calibrated timestamp showed that there was no one present at a particular moment in time, and the testimony was otherwise. Maybe that would be a basis to set that aside. But when we're talking about the interpretation of material that was before the trier of fact and I guess I'll keep an open mind, but I'm not familiar with any principle that puts us in a position to conduct a de novo review and perform our own independent interpretation of that evidence.
Your Honor, I would say I believe the case is Tremblay that I had cited, and it's around page 19 of my brief, and that would be the case citation. And I do understand your point that he ended up having a credibility determination. Unfortunately, it was a credibility determination of evidence that probably was improperly admitted. But putting that to the side, I think that the point here is that you are not bound to follow that when it is based on a document. And if I could just finish in the short time I have left, the point here was that the other officer said it was blown out, it was zoomed in. And if you look at the picture, you can see that there is light that makes it impossible to determine what the person's facial characteristics look like, what their skin tone look like, their facial hair, their tattoos, anything. It's inconclusive evidence is, I suppose, what I am saying. And the fact that one person who had no information about this case concluded differently shouldn't be determinative to your honors. And I would say that these small pieces of information, even though they slightly add up, do not rise to the level of preponderance of the evidence. And on that basis, I would ask you to reverse the judge below.
Thank you. For the Commonwealth.
Thank you, your honors. May it please the court, Shannon Buckingham for the Commonwealth.
Ms. Buckingham, before we get too far along, I guess I'd be interested in hearing what you have to say to the defendant's argument concerning restitution.
So in this circumstance, I would agree that the restitution issue was not so clear. However,
before we get to, I want to circle back and ask you to frame in more legally precise terms what you mean by not so clear. But if we reach the conclusion that the evidence on restitution was insufficient, are we also in agreement that the failure of evidence on one of the alleged violations alone would require a remand for redetermination by the judge?
Well, in reading the judge's findings in this particular case, I would suggest that this court has sufficient information before it, based on the findings, to find that it.
I was on a panel years ago where we thought that was a really good idea, and the SJC took a different view.
Well, I would just say that Judge Cosgrove made sufficient findings, and he made substantial findings of fact regarding the criminal offense.
He could have six homicides and a failure to report to probation. But if the failure to report to probation was either an impermissible ground or unproven, we have to remand. It's always struck me as kind of a silly requirement, depending on the severity of the violation in particular. But they get to make those choices on the second floor.
I agree, and I can appreciate your
on all days, with Chief Justice Gance's memory looming in our background, I would be loath to disagree with the Supreme Judicial Court.
Agreed. But as far as it pertains to this restitution issue, I would concede that PO Probation Officer Yon did indicate that he was unable to find any information. But I would also
it's the Commonwealth's burden, right, on to prove the failure to make restitution.
Correct, and we're talking about preponderance of the evidence standard, as your
the absence of any evidence of payment means. I'll invite you to tell me how the absence of any evidence of payment would satisfy the Commonwealth's burden to prove, or non-payment would satisfy the Commonwealth's burden to prove failure to make restitution.
Well, I believe there's testimony by the probation officer that there is a way in which they can check to make sure that payments were made to the court, where he talked briefly about.
And did they do that?
The probation officer, I believe, did testify that he checked mass courts to determine whether any payments were made, and that there were none. There was clearly an order by the court that the restitution be paid. The dockets were before the court to show that there was no order from a subsequent court that would have remitted that restitution or determined that that restitution did not need to be paid. So I would suggest, based on a preponderance by the evidence standard, the fact that the probation officer did in fact go back, check the system to make sure and see if payments were made by Mr. Rodriguez in regards to these matters, and the fact that there was none was sufficient evidence to show that there were no payments made, and therefore he didn't comply with the restitution order.
Okay, let's run through the other non-criminal violations because I think we need to, unfortunately, we need to conduct that same inquiry, that same analysis as to each of the charge violations. In some of these cases, maybe it would be more conservative, more straightforward to not to overcharge. But let's go through the others.
Not to issue additional notice for
Right.
all of them. Okay.
Right. I mean, the kitchen sink approach can unnecessarily, in some circumstances, create a risk that the judge, in a moment of haste, enters a finding on a violation that isn't proved, and then we have to go have a do-over.
Okay.
Look, you guys get to do this however you choose to do it. I'm also very respectful of the separation of powers. I'm just making an observation that some of these conversations we wouldn't be having if we all focused on the core question.
Correct. I would agree with that statement of Your Honor. Addressing the other non-criminal violations, counsel's already conceded that obviously
Right.
Mr. Rodriguez did failure to report. So we're really talking about the DNA. And I would disagree with counsel's argument that the fact that Mr. Rodriguez was determined indigent at one point during these proceedings, whether it be the original case or the probation violation, the fact that he is indigent then alleviates him of his ability or the necessity for him to pay that fee. In his initial conditions of probation, he's notified. He was convicted of enumerated felonies that would require him by statute to provide that sample. So he was under the obligation to provide the sample, and attached to that obligation to provide the sample is also the obligation to pay for the sample. The fact that he was indigent and received court-appointed counsel never allows a probationer to automatically be alleviated of their obligation to pay any sort of fees. Any subsequent determination of fee waivers needs to be conducted on a case-by-case basis by the judge, and there's no evidence in this case that was conducted. So I would suggest that the defendant's failure to pay the fee, there was sufficient evidence to show that, and that the probation officer testified to that. All the documentary evidence was put into evidence to show that it was his obligation to pay that. And the fact that he initially was signed orders or signed conditions of probation, where that's one of his obligations, that he's on notice that if he didn't pay, that could serve as a basis of a violation. So I'd suggest to you that's sufficient in order for the court to have found him in violation, because it was clearly that he did not pay.
Is it your sense that it's fairly common for a defendant determined to be indigent to, over the course of a case, come into an inheritance or otherwise get out of that indigency?
Yeah, possibly yes, especially since most people who are released from a custody situation and put on probation, they're seeking work, and a lot of times that is a recommendation of probation for people to continue to stay out of trouble and be able to comply with all their conditions. But just because a person's indigent doesn't mean they automatically have their fees waived. As I said, it's a general practice, I think, for the trial courts when a probation matter comes before the court, for the judge on the bench to determine whether there's that ability to pay. And that's why people are given an alternative in most circumstances where fees are at issue, to have an alternative to pay the fees by doing something like community service. I don't believe a DNA.
What about the missed random drug test?
So counsel, logic in her brief is that because he wasn't scheduled for a random test to come in on a day that he wasn't scheduled for probation, that he wasn't on notice.
So this is the Commonwealth's burden. So what is the evidence that he missed the random drug test? Just
Well, I
the fact
think-
that he missed the scheduled meeting?
I think that the violation, the language of the violation that's put in the document is that he failed to submit to random testing. Not that he failed to submit to a particular day or he failed to.
Right. I mean, that's
What is
the
evidence of that?
Well, I would suggest to the court that random testing means it could be conducted at any time. And for the probation officer to indicate that he didn't even appear in person for him to have a meeting, so therefore he didn't have the ability to test him, which I believe was the probation officer's testimony at the hearing.
His testimony was that there was a notice that he was to appear for a meeting at which he would be tested.
His testimony was that he didn't have the ability to test Mr. Rodriguez for the drug testing requirement because he never had the opportunity to meet with
But was
him.
Mr. Rodriguez informed that he should appear for the purpose of being tested?
I don't think, Your Honor, that oh, sorry, my time has
You
expired.
may answer the question.
I don't think that it has to be that specific. I think that
Well, I mean, so he didn't appear the day before that either, right? I mean, random is random, but I think at some level he has to be informed that he's being asked to submit to a drug test, doesn't he?
But based on the record and Probation Officer Yan's testimony, Probation Officer Yan never even saw Mr. Rodriguez because he hadn't appeared to any of the visits to outline what that obligation would be. So
Okay. I understand the argument. Thank you. That will conclude the argument in this case. The panel will take a brief recess. We will resume with the next case at 11:15.
We are live and on the record.
All right, we resume our session this morning with the civil portion. We have two cases remaining, the first of which is case number 2019 P1024. And before we begin the argument, I just want again to remark that at the opening of the session, before the first case this morning, I gave some remarks commemorating our loss of our leader and friend, Chief Justice Ralph Gantz. I will not repeat those here. For anyone who is interested in viewing those, they can look at the archive of our recorded argument today. But I do want to observe that we are continuing today as he would want us to. The justices of the Supreme Judicial Court have directed that all courts across the Commonwealth will be closed tomorrow for a day of remembrance, and we are in business today. So with that, Counsel, you may begin.
Good morning, Your Honor. May it please the court. My name is Michael Lewis, and together with co-counsel Attorney Angela Marcolina, we proudly represent the Boston Housing Authority. As stated, we'll be splitting time. I'll be addressing more the technical errors of law committed by the lower court in this case, and my sister will address how those technical errors impacted the outcome of this case, but both of us are well-versed in the entirety of the case. I'm going to start with a quote from the lower court in which Judge Winnick said, "Yesterday, the appeals court affirmed that I decided the mere fact that BHA may be in error does not trigger a 1983 violation if they otherwise made the decision following the proper process. I do think, in fairness to you, by remanding the case, that issue goes away, because the BHA will be affording your client administrative review." And Attorney Zakim responded, "Yes, Your Honor." That's at Sup Appendix 52. And I think it's relevant in the fact that the BHA gave the plaintiff 3 hearings. One was the initial termination hearing. There was a second reasonable accommodation. The second hearing was a reasonable accommodation hearing. And then there was a third hearing, which was the second reasonable accommodation hearing.
Okay, but there's the issue of the process that was provided, but the tenant here prevailed on her discrimination claims, correct?
That's what the judge purports to do. Although if the court looks at the lower court's decision, 1983, it's not reviewed under 1983, it's reviewed under writ of certiorari.
Well, that's what we're deciding. The judge appears to have resolved this under the suite of discrimination statutes, including 151B. Those cases are resolved in court, correct? Not by a hearing officer in front of the authority.
Correct, Your Honor. And I would say what also lays credence to the fact that this was a writ of certiorari case 1993 is no
Well,
motion.
it seems to be a hybrid combo case, if you will. But it is true, you would concede that typically speaking, these kinds of discrimination cases are resolved by the court in a lawsuit with a judge making findings and so forth, correct?
No, Your Honor. I would say that in a large volume of the Housing Authority Section 8 terminations, which often include discrimination complaints, they're resolved through 249 Section 4. If the court looks at the Marianne Brown case versus the Boston Housing Authority, which was cited in our brief, it's the exact same issue. That court cites Wojcik about what I've said, is that the fact that while BHA provides the process, it doesn't act in its own peril. I would say if the court looks at the Figs case, the Seals case, those are cases that are all decided under 249 Section 4.
But I mean, given the nature of a discrimination case, why would a court defer to the hearing officer for the agency with regard to facts and claims typically resolved by a court?
Because I think there's an underlying record here, and it's typically the hearing officer took all the testimony, and actually, shadowing Your Honor's point, then if this was under 1983, there should have been a trial or at least motion for summary judgment.
No party asked for it. This is a really interesting, strange context where the parties themselves agreed that the universe of evidence, if you will, was going to be the administrative hearing record, and then presented it to the judge in the form of a motion for judgment on the pleading / summary judgment, and an opposition that reads like a cross motion. The parties now seem to agree that there is de novo review by us. I'm not even sure that is correct in a situation where it's unclear why we're talking about record review anyway.
Well, I think the court hit the nail on the head. This court, we think that this court can review de novo. The other option is to remand it back to the lower court to fix these procedural errors. And
have a trial on the discrimination cases.
Yeah, that's certainly a possibility, because there are absolutely factual disputes between the parties on this. So summary judgment, if it's 1983, wouldn't be appropriate. I mean, VHA would say the court directly said 1983 goes away if you hold these hearings. In addition, the lower court orders this third hearing, but doesn't even address it. Nowhere in the record the third hearing decision isn't addressed. If you look at RA 557 and RA 580, RA 557, the court goes to the procedural history and it stops after the second hearing. He orders this third hearing for the hearing officer to.
So why would we remand for a full trial on the 1983 case when both sides conceded that it should be decided on the administrative record?
I think that the issue is that there was some confusion about how the court was handling this. I can tell you from the BHA's perspective, we believed throughout the entirety he was handling it as a 249 Section 4. And if you look through the transcripts and the hearings that was held by them. Is
it your position that BHA did not concede that 1983 should be decided on the administrative record?
I would say that, Your Honor, yes. Because there's
you did not concede that.
I don't think we conceded it, no, Your Honor.
Well, but the 1983 claim was framed. It was there, and I don't know how you can agree that the case will be resolved on the administrative record without necessarily importing all of the claims that are framed to be dealt with in that manner. I don't know what that means.
I think there's, and my apologies, I think there's a lot of confusion about the fact that there was a number of hearings.
I understand that there may have been confusion, but we are well accustomed to handling unpreserved errors on the criminal side of the house. Waiver is still alive and well on the civil side of the house, and in a civil trial where the parties agree on how the case is going to be adjudicated, that I think binds the parties. And then the question is, who had the burden. If there is a failure of proof, then that's the party with the burden is the one who suffers the consequences of an inadequate record.
Understood, Your Honor. I think it is important for this court to look at the fact that the lower court required the hearing officer to disregard relevant case law, the Jackson case, which was directly on point with the issues in this case. The lower court directly says, I don't like this case, hearing officer, don't follow it. But is it an error for the hearing officer to follow that? I think that doesn't fall within the framework of 1983.
I get that. Okay, we'll hear from Attorney Marcolina.
Thank you.
Thank you. Good morning, Your Honor, Chief Justice and Associate Justice of the Court. My name is Attorney Marcolina, and I will pick up where my co-counsel has left off. I'm going to talk about the errors and how they affected in the context of the case, but I do want to just address that the court has asked if the parties conceded as to how this case was handled, how is it an error for the judge to have found that there is a 1983 violation? And I would point to the record and say the error is that if the judge is also examining whether or not there's a 1983 violation, the standard is summary judgment. The judge never discusses that standard in his decision.
But we can nonetheless consider the legal questions de novo, right?
You can.
Okay.
Yes.
Yeah, but
So where does that leave us in your view?
Where that leaves us, I believe, is that the BHA in this particular instance followed its policy, followed the law, and the fact that a decision is rendered that is in opposite to what the plaintiff would have liked on its own is not a violation of 1983. In fact, in this case, when the court looks at the record, there's never a deprivation here of her subsidy, ever.
Was there an obligation to provide a reasonable accommodation?
No, not under these facts, no. And I'd like to get into that if the court would allow.
Please.
Sure. So the BHA's position in this case was that it was a reasonable accommodation was requested post termination hearing. The BHA immediately took that request, engaged in the interactive process, and rendered a decision. That initial decision was a denial. The court will see that the BHA's process at that point, because the case was already in litigation, was to allow the court to then issue a decision. The court wanted the BHA to take this case back and give an administrative hearing, which my brother has already talked about. That hearing happened and a decision was issued. The hearing officer's decision was framed under Bridgewater's. There is obviously reference to Rucker because Rucker is an important concept and important for this case. The lower court judge, the court will see at RA 530 and 531 indicates that, and I'm going to quote the court. He says, I think the problem is that the law requires that your client be entitled to an accommodation that puts her in the same position as a tenant without a disability. But the harsh response is, I think that absent a factor such as because of her disability, she couldn't control his comings and goings from the apartment, that she was responsible the same as another non-disabled individual. And that's where this case sort of takes a divide, because control is defined in Rucker. And control is whether or not an individual is on the property lawfully. The court will see in this record, in the first transcript and throughout, the participant herself testifies. He is caring for her, but he also visits her. He's her son. The hearing officer finds he's a guest. He's not a PCA. He's not an individual that's hired as a PCA. He is not a PCA approved by the housing authority. He is her son. He's a guest. And
Can you say that the tenant points to part of the record where counsel for the BHA appears to have conceded that he was there to take care of her?
And the court will see that that comes up in arguments as well before the lower court, and the BHA quickly corrects that. The BHA never concedes he's there to control her, he's there to care for her. What happens in this case is that initially the termination hearing happens and there is no reasonable accommodation requested. The hearing officer takes the evidence, which is very limited. Questions are asked about why she's submitting evidence, and he makes the determination at that point that the evidence on disability is submitted to show how it affected her health, how the event affected her health. And he considers that evidence as mitigating. The lower court seems to, if you will, rewrite history, because at that point in time, there is no reasonable accommodation request. So,
well, I mean, to be fair, I think the lower court is saying she did enough under Bridgewater to raise the reasonable accommodation. And so go back and do your reasonable accommodation hearing. And so that's what BHA did. I guess my question is, what is your position on the nexus? That I thought that was the core of the argument, and I'm missing it here in oral argument.
Yes. So the BHA's position on nexus is that there is no nexus here. Bridgewater's is clear that you need to have a direct causal connection between the disability and the underlying eviction or challenged action.
And
here,
she's saying I had to have him in my apartment because I have this disability that requires somebody with some strength to pick me up when I fall.
Correct.
Well, and beyond that, because of my disability, I was not unable to determine that he was violating the terms of the tenancy.
Right. And again, I would point the court back to Rucker. So the issue is, if her request was that she couldn't control his comings and goings because it's conceded that he's invited, he has keys, he has unfettered access. He comes as her son to visit her. He may also come to aid her, but she has many people coming to aid her. In fact, when the court looks at the record, the medical record closest in time is the EMS report, which says the police begin to take down the door, and it's not her son who answers the door, it's her. And her sister, who's also there.
We're getting back to the procedural issues because the judge made conclusions in the nature of findings. And to the extent that those are proper findings, we don't go beyond them unless they're clearly erroneous. Part of what I hear you, both of you arguing is, oh, this wasn't appropriate for findings. This was summary judgment. And we can determine if that issue has been waived or not. But to the extent the judge made these findings, you're stuck with them, aren't you?
I would argue that no, because the BHA's argument is that he sets out in his decision that he's reviewing the case under 249-4, which doesn't allow for him to make his own findings. He never sets a standard out under summary judgment. He doesn't do that. And I know my brother has touched upon this.
No, but where the parties agreed that, okay, here's the evidence we want you to look at. They didn't appear to say, here's the evidence we want you to look at, but only for the purposes of summary judgment. And we want a trial down the road if you disagree.
That's correct. I understand that that's the court's position. I think what the BHA is saying, though, is that if in his order, he dismisses the 249-4 claim, which he does, and he says, I'm finding under 1983, if that was how he was resolving this case, he himself doesn't apply the correct standard in his decision. And furthermore, he completely forgets that there's a third hearing and a third hearing decision and never mentions it. In fact, he doesn't overturn it in his order.
Okay, I see the time has expired, but I have one question I feel compelled to ask. And that is, under your interpretation of Rucker, the authority still has discretion to allow this woman to keep her Section 8 subsidy. Could you just, in simple terms, explain why the authority doesn't use that discretion to allow her to keep the subsidy under these facts, where she has put forward a plan that the judge at least believed would solve the problem going forward?
Sure. The authority doesn't take that position because this is an individual, a guest who's involved in a heroin trafficking ring. And frankly, when you look at the facts of the case at the time of the incident, the very plan that she has suggested was already in place. She had a cleaning person at the time who counsel submitted photos saying the cleaning products were in fact in the closet where the safe was. She has a sister who's also there helping her. She also had a neighbor who came and testified at the administrative hearing that was also helping her. So the plan to have different guests continue to care for her was the plan at the time of the incident. There were already many other sets of eyes. And also because the BHA has no relationship with that person. It's not the role of a PCA to what the judge creates as a legal standard, detect and address criminal activity. So it wouldn't be reasonable.
I think we're going to have to leave it there. Thank you very much, counsel. And we'll hear from counsel for the plaintiff.
Good morning, Your Honors. My name is Dina Zakem, here on behalf of the plaintiff appellee, Ms. Moret-Talara. May it please the court. Ms. Moret-Talara's case is about a tenant with disabilities who needed help in order to live safely and independently in her home. BHA is trying to terminate her subsidy because, unbeknownst to her, one of her caregivers, her son, was involved with drugs. She asked for an accommodation to replace him as a caregiver, bar him from her home, and continue to live successfully as she had in her Section 8 housing for the 15 years prior. It's been 4 years since BHA denied that accommodation, and since Ms. Moret-Talara barred her son, got a different caretaker, and has had no problems. But the BHA still seeks to terminate her subsidy today. This would render her homeless and deny her equal opportunity to housing, exactly what the reasonable accommodation provisions of the Fair Housing Amendment Act were intended to prevent.
So can I stop you there, counsel? Why is this an equal opportunity to housing problem? If she wasn't disabled under Rutgers, she doesn't have the defense of being an innocent tenant. It seems like because she's disabled, you're arguing she's advantaged in that she does have that defense.
No, Your Honor, under Rutgers, it spoke about the innocent tenant defense, but it explicitly did not, it expressly noted in its footnote that it was not addressing the ADA or any fair housing claims. And it left room for the Ninth Circuit to conclude, as it did, that while all the other tenants in the Rutgers case were out of luck after Rutgers was decided because of the no innocent tenant defense, that because the fourth plaintiff, Herman Walker, who was being evicted based on his PCA's misconduct, that he was entitled to an RA and could continue his tenancy post-Rutgers. They looked at the fact that a person with a disability who relies on caregivers to come into their home and take care of them does not have the ability to exclude them from their home. They need that outside care in order to have equal access to their housing. And what would be reasonable and practical is to do what Ms. Moret-Talara asked and what she has put in place by just replacing that wrongdoing caretaker and barring him from the unit and allowing Ms. Moret-Talara to continue in her home.
My other question is, why is the third hearing, why are the conclusions from that third hearing not dispositive here? The hearing officer seemed to conclude that as a matter of fact, her disabilities did not prevent her from detecting the misconduct.
That finding is not material because Ms. Moret-Talara already satisfied her but-for causation on her first causal link. Here we have established two causal links. The first is that Ms. Moret-Talara needed her son to come care for her because of her disabilities. As we discussed earlier, BHA did concede that he was there to care for her and there in his capacity as a caretaker. Both hearing officers in the termination decision and in the reasonable accommodation decision acknowledged that he was there for sympathetic and legitimate reasons. And as my sister noted, in the actual transcript of the hearing where that discussion went on, Judge Winnick was talking about how if the son was there to care for her, then that would be a nexus. And Attorney Marcolina answered, it wouldn't be a direct connection. It would say that's why she's there, why he's there, but not why he's engaged in drug-related criminal activity. So it's clear that they concede he was there to care for her and concede that's what was going on. Once we established that causal link, it became the BHA's burden to prove that it was not reasonable.
Well, stop there. So I just want to make sure I understand the argument. You're saying that the but for causation, that he was there to care for her, is by itself enough to establish a nexus?
Yes, that would be a causal link that satisfactorily connects Ms. Maretta-Lara's disability to the violation here. And that is actually what the Ninth Circuit held in the litigation leading up to and surviving Rucker, where they looked at the fact that Mr. Walker, because he relied on that PCA coming in to help him, and the PCA's misconduct is what was leading to his eviction, that was enough.
But would that mean that even if your client was aware of the drug dealing activity, the mere fact that her son was there is enough to?
No, Your Honor, but that's not what the case is before this court today. The record does not show any reason that she should have been aware of.
No, but that's a different issue. You were arguing.
That's a different issue. That's a different case. What the record shows here is that this was unexpected criminal activity. BHA even conceded that Ms. Maretta-Lara did not know of the activity. That's in Record Appendix 156, and the hearing officer notes it in her decision at 366. So the BHA doesn't allege knowledge. They had as an opportunity.
Okay, but are you conceding that for the but for causation of why he was there to be enough, it has to be coupled with lack of knowledge of the activity?
No, Your Honor, it doesn't have to be coupled with that, but it does have, the record has to show that it's reasonable. And part of looking into what's reasonable is if the BHA, which is their burden to show if it's reasonable, would have had to put in evidence in the record to show that there was some reason that she should have been able to stop it. She should have known about it. They did not do that.
But isn't it your burden to show a nexus before the burden flips?
Yes, and our burden is to show that as a result of her disability, she relied on in-home care. And because of that, she was unable to take if a Section 8 tenant can accept the fact that they live under these strict program violations, they can take precautions and say, okay, I'm just going to be careful. I will not let people come into my home. Ms. Maretta-Lara and other tenants with disabilities who rely on in-home care don't have that option. They can't just exclude someone. So if Ms. Maretta-Lara would—
Why do they have to pick somebody who's a heroin trafficker?
That's the thing, they don't have to pick someone. And like the case here, once that became apparent, Ms. Maretta-Lara replaced her son as a caretaker, barred him from her home, and has not had any problems since. If she was arguing that the accommodation would mean that she has to keep her son as her caregiver, allowing him to continue any sort of drug activity, we would agree that that's not reasonable.
But what the Walker plaintiff did? I thought the Walker in the Ninth Circuit, I thought Walker was warned several times, your PCA is dealing drugs. And are you saying the Ninth Circuit said a reasonable accommodation is you have to keep that drug dealer? Because
no, in the end of Walker had worse facts than our case here, because like you said, he had been warned several times. In Ms. Maretta-Lara's case, this was the first incident, the first warning, and she has taken action since then. In his case,
what you're suggesting is that a person who needs a PCA is entitled to have each PCA offend once with impunity.
Well,
as I understand the argument.
That's not the way I would phrase it, but BHA's—
Well, I know it's not the way that you would phrase it, but I guess, is that not the effect of what your argument?
Technically, that would be allowed, but BHA's own reasonable accommodation plan and the case law demonstrates that reasonable accommodations can be requested as reasonable second chances. Their plan—
But the question I'm asking, I guess, chips away at the reasonableness of the accommodation that you are proposing, because it has the effect of meaning that any person coming into the apartment may offend once, and unless and until that is brought to the attention of the tenant, there is no violation.
No, the tenant has the responsibility to act reasonably under the circumstances. BHA has the burden to show that in this case, she didn't act reasonably. Each case stands on its own facts. Here, the record shows that upon this first violation, Ms. Maretta-Lara is now barring her son and replacing him, and is not trying to continue. If the facts were different and she had repeated violations, it would be different.
Suppose she could have known upon sufficient due diligence that her son posed a risk of drug dealing if she had him live with her as a PCA.
If she could have known?
Yes. I mean, what we're talking about reasonableness here, and again, if we're going to avoid the, I think by your, you didn't say in so many words that you agreed that it would be unreasonable to give impunity for for one offense by each caregiver. So if we're looking at reasonableness, is it unfair? Is it unreasonable to impose on the tenant a duty in the first instance to conduct some form of inquiry before engaging a PCA who poses a risk of, or at least to the extent that could be ascertained ahead of time?
If there had been anything in the record to suggest that she should have been aware of this and not taken him in as a PCA, this case might be different and it might be deemed unreasonable. But what we've looked through for reasonableness is whether it creates an undue financial burden on the housing authority or a fundamental alteration. And it's BHA's burden to prove that. We have proven that there has been a causal link.
Well, can we get back to nexus? Because yes, there's a second piece to this, which is whether or not her disability interfered with her ability to appreciate and perceive the drug dealing. And on this issue, the hearing officer, one of the hearing officers, and the judge went in diametrically opposed directions, where the judge, in essence, found that it did, and the hearing officer, in effect, found that it did not. This gets back to the procedural posture of this. First of all, do you agree that what the judge said on this point is in the nature of a finding? And second, is that proper in light of the procedural context of this case?
So the parties agreed to record review here. They did not agree
to— What was the nature of that agreement? Is it oral during the hearing, of which we have no transcript, or is it some writing somewhere?
It was just agreed that what had happened before was going to be reviewed for whether it was clear that Ms. Martellara did face a reasonable accommodation denial, an improper denial. The BHA may forget that Ms. Martellara had affirmative fair housing claims in her complaint, and that is what the judge decided on here. He did decide that on record review, so he was stuck with the findings of fact as made by the hearing officer, but only based on whether they're also supported by substantial evidence in the record.
But that's not what the judge said. He didn't say, I find there was not substantial evidence to support the hearing officer. What he said was, I find there was substantial evidence that X is true. So they really do, at least to my mind, read like findings.
What he was looking at, he was sticking to the record as found by the hearing officer. And even in the point that BHA quotes in terms of quoting the fact that he was making factual findings, they quote a part where he says he's looking at the hearing officer's decision to see whether her findings were based upon legal error. And that is correct. That's what he did. He based it upon legal error. He looked at the fact that the hearing officer was applying improper causation theory, requiring proximate causation and direct causation, and not looking at Bridgewater's correctly. I mean, even in our argument today, Attorney Marcolina said that Bridgewater's requires a direct causal connection. Each time the Bridgewater's case is mentioned, they add this word direct. There's no such word in the Bridgewater's case. It requires a causal link. Here, Ms. Martellara has established that causal link, and that is the fact that the incident only happened because her son was there to take care of her. The incident was her failure to cause her son to refrain from the activity. If her son was not there and didn't have to be there as her caretaker, it wouldn't have happened. The evidence in the record supports that he was there as her caretaker.
But
Now,
didn't the judge rely in part on the second piece of this, which was whether or not her disability interfered with her ability to perceive the violations?
The judge did look at that second piece, and it is a second independent ground for nexus. While Ms. Maritalara did not have the burden to prove that second causal link, we did prove it here, and that's shown in the evidence of the undisputed medical records and the other facts in the record, including what BHA conceded to. The hearing officer's review was looking at the facts based on the wrong grounds, the wrong legal analysis. She was looking at whether it was this direct causation, and she even applied the incorrect standard of proof of requiring dispositive evidence rather than the civil standard of proof of preponderance of the evidence. That was one of her mistakes there. And even she concluded that Ms. Maritalara would not be entitled to have an accommodation because an accommodation isn't available to a tenant without disabilities. And that doesn't make any sense. Her decision was based upon legal error, and the record supports the facts that would support Ms. Maritalara's affirmative fair housing claim. And the appeals court is able to affirm on any grounds in the record here.
We're gonna have to leave it there unless there are further questions from the panel. Okay, hearing none. Thank you all.
We are live and on the record.
All right, we resume with the fifth and final case on our list for hearing today. I want to explain the delay. We had some technical difficulties while we were running our sound check with counsel as they were admitted from the waiting room. Before I call the final case, I will again note that I offered some remarks at the beginning of our session before the first case this morning in memory of our departed leader and friend, Chief Justice Ralph Gantz. I will not repeat those here, other than to observe that the justices of the Supreme Judicial Court have called for a day of remembrance tomorrow, on which all courts across the Commonwealth will be closed in honor of his legacy. We are, of course, in business today, and he would want it no other way. Let us do our best to honor his legacy by pursuing justice. The last case on our list today is 2019 P 1829. The case name is Brian Lacaraza versus Veronica Darling and others. You may proceed.
Members of the panel, may it please the court. The issue that has brought us here today was the tribunal's error in its appraisal of the proffered evidence in the offer of proof, which resulted in a finding that the offer of proof did not meet the statutory threshold. This is a serious case. It is about a man named Richard Lacaraza who died at the age of 63 after receiving substandard medical care from the defendants following a left total hip arthroplasty. In summary, the defendants failed to provide proper postoperative care and recognize, appreciate, diagnose, and treat Mr. Lacaraza's acute abdominal process, the failures of which are outlined in the plaintiff's expert letter contained at Record Appendix 1, pages 217 through 223.
Let me simply observe, counsel, at the outset that we have a number of separate defendants. The facts relating to each are different, and this is, of course, a quite fact-intensive case. I would assure you, first of all, that the panel has read the materials for the case. We are familiar with the record, but and you should use your time as you see best. But I would encourage you to focus as concisely and directly as you can on the facts as they relate to each individual defendant, and highlight as best you can why it is that the tribunal was wrong as to each defendant.
Sure, Your Honor, yes. I would first like to state that as the panel is aware, the tribunal's statutory directive is to decide whether the evidence presented, if properly substantiated, is sufficient to raise a legitimate question of liability. Previously, this was interpreted to mean that the offer of proof is measured against a directed verdict standard, for which whether any whether anywhere in the evidence there could be a reasonable inference in favor of the plaintiff. However, more recently in the Feliciano versus Adenucci case, the appeals court made it clear that even that standard may be too burdensome because it is done at a different stage in the litigation. At the tribunal stage, the parties don't yet have the benefit of discovery, so all inferences must be drawn in the plaintiff's favor. As outlined in the standard of Cap versus Ballantyne and Sanders versus Reddy, I will start addressing the evidence presented that each defendant failed to conform with the standard of care. Dr. Drew very clearly stated in the postoperative period and throughout the evening before his passing that each of the defendants that saw and examined Mr. Lacaraza, which included PA Hiles, Dr. Patel, Dr. Pham, and Dr. Fernandez, should have recognized and appreciated the signs and symptoms of an acute abdomen, which he details clearly in his letter. They should have performed an NG tube insertion, which undoubtedly none of the defendants did, and which he claimed is the urgent treatment required for an acute abdominal process. They each should have ordered a surgical and/or GI consult, which none of the defendants did, and also order radiology imaging and follow up on the results or appreciate the findings of such. Dr. Drew then faults the last two defendants, Veronica Darling and Dr. Quadri, not for the same failures as the previous defendants, because by that point, Dr. Drew has considered the patient's condition has changed and it's worsening. He's critical of PA Darling and Dr. Quadri's failure to evaluate the patient at bedside when contacted regarding his worsening condition, which really equates to just seeing the patient, evaluating the patient themselves, ordering a central line or a PIC placement when IV access is not attainable and they were informed there was difficulty, in response to Dr. Quadri himself stating in the record, we need to obtain access, keep trying, ordering transfer to the ICU when the medical condition requires closer monitoring, which is evidenced by his worsening condition for which they were being called. I would like to now address the arguments that were brought up by the defendants as to why Dr. Drew is not qualified to give a standard of care opinion as to each of these defendants. The first argument that was raised was that he was not qualified to give a standard of care opinion as to a PA or the defendants practicing in their various subspecialties of internal medicine, which included critical care and nephrology. On the contrary, Dr. Drew is qualified. He is board certified surgeon since 1982. He attended Georgetown Medical School. He trained at the Mount Sinai Medical Center. He's familiar with the standard of care for these defendants, which he stated in his letter, and he is clearly has experience caring for postoperative patients, which is what these defendants were doing. It has been well established in this Commonwealth that the plaintiff's expert need not be in the same specialty, and that the tribunal may only refuse to accept his opinions if it's so deficient that as a matter of law, it would be improper for a judge to admit it. The opinions of an expert are to be received even if the tribunal might decide that in the exercise of its discretion, it would not accept that expert as qualified, according to the Cap versus Ballantyne case. Here, Dr. Drew, a surgeon, is familiar with the postoperative care given to surgical patients. He's a surgeon. It's his opinion that the appropriate treatment for this patient likely involves surgery, and in fact, the patient's course did include surgery in an attempt to remove his ischemic bowel and save his life, although it was far too late at that point. Dr. Drew has stated that he was familiar with the standard of care for the internal medicine physician and PAs providing care to a postoperative patient. In his expert letter, he refers to Dr. Patel as internal medicine and critical care physician. He's aware that Dr. Pham is performing a consult, which is contained in his letter. Both of these doctors, as well as Dr. Fernandez and Dr. Patel, are board certified internal medicine physicians with a subspecialty. Similarly, both of these physician assistants are PAs practicing in a subspecialty. To argue that because these physicians or PAs have a subspecialty, that they then don't have to abide by the standard of care for their board certification, that of an internal medicine physician and a PA, is a stretch. That would be similar to saying that I don't have to abide by a standard of care for an attorney, only a litigator. These two things are not mutually exclusive. Not to mention, if the defendants believe that the standard of care for them is different than what my expert says it is, that is ultimately an argument for trial. While it's Dr. Pham's and Dr. Patel's positions that in their roles and subspecialties, they were called in for limited purposes, That is an appropriate argument for trial, not at the tribunal stage. For the purposes of the tribunal, they were practicing as internal medicine physicians, and my expert, Dr. Drew, has opined to the standard of care. If Dr. Pham would like to argue, as laid out in his brief, that because he came in for a nephrology consultation, or to perform an admission to the ICU, trial is the appropriate venue for that. This is a case where fully board certified physicians and PAs were providing care. In fact, I would refer you to the notes of the defendants. They each take a history, they perform a physical exam, they issue orders. In terms of Dr. Patel, he does not solely decide whether the patient should go to the ICU, as he claims. He decides to hold diuretics. He suggests non-invasive ventilation. He opines on the use of oxygen and IV fluids. He orders blood work and imaging, which is all contained in Record Appendix 1, pages 70 to 73. In the case of Dr. Pham, he is noting a finding of metabolic acidosis, one of the signs and symptoms of an acute abdomen, which my expert says he doesn't appreciate, but also is coincidentally a renal condition for which he is allegedly a subspecialist in. He orders an imaging study for thrombosis. He orders labs and an assessment of antibiotics. He's having informed consent conversations with the patient regarding dialysis. And similarly, Dr. Fernandez is likewise evaluating Mr. Lacaraza in response to complaints of abdominal pain and distension, which is contained at Record Appendix 1, pages 192. The defendants frame their arguments in a way to suggest that because I'm specialized or I was consulted, I'm not responsible. All of these providers were assessing Mr. Lacaraza in person, except for those who were faulted for not doing so, performing physical exams of him, placing orders, and they're held to the standard that my expert has laid out, which for the purposes of a tribunal must be accepted as true. There is no dispute that none of these defendants offered, ordered, or performed a G-tube placement, offered, ordered, or performed a surgical or gastrointestinal consult, among other failures, which my expert has specifically linked to a worsening clinical picture and death. A second issue that was brought up by the defendants was that Dr. Drew was critical of their failure to recognize and appreciate an acute abdominal process, for which he defines what those symptoms are at Record Appendix 1, pages 220. The defendants have maintained, since not all of those symptoms may have been present at the time that particular defendant saw Mr. Lacaraza, that Dr. Drew's opinion is not rooted in fact. First, Dr. Drew merely lists the signs and symptoms that occur with an acute abdomen. He in no way states that all needed to be present for that diagnosis. And in fact, to the extent that even one is present, I would argue that's enough, and then appropriate for cross-examination at trial as to the weight of that evidence. We know that as of the time that PA Heil saw Mr. Lacaraza, documented in the medical records is that he had indigestion, his abdomen was distended and firm, and he had loose stool. And I would refer your honors to Record Appendix 1 at page 64 and pages 109 to 110. At the time that Dr. Pham, Dr. Patel, and then Dr. Fernandez see Mr. Lacaraza, he has had all of those symptoms, including metabolic acidosis, which Dr. Pham himself documented. He also has vomited by that point, which is contained at Record Appendix 1 at page 70. It was Dr. Drew's opinion that the defendants did not recognize and appreciate those signs and symptoms. In their briefs, counsel for the various defendants pointed out indices of contradictory evidence, absence of a symptom, or a failure of that particular defendant to note a symptom at that time, and also questioned whether the defendants had all of the records at their disposal. At this stage, the tribunal stage, it's inappropriate for the panel to consider the contradictory evidence or presence of other symptoms which may have pointed to another condition, because that would be involved in an assessment of the weight and credibility of the evidence, which is not the tribunal's function. All inferences must be drawn in the plaintiff's favor. It's not appropriate to take contradictory evidence in the defendant's favor. And I would refer the court to the Green versus Al Jazeera case, 92 Mass Appellate Court 1126, which is a case involving a patient who presented with multiple symptoms, and the court found that just because there are contradictory symptoms or symptoms that may have led the defendant down another path, that does not suggest that that defendant was not negligent. Turning the court's attention to the issue of causation, which was also brought up at the tribunal. The defendants contest that the plaintiff's causation was not sufficient to link the injuries and death to the care. Here, the plaintiff has done that. Dr. Drew has opined in his expert letter as to what the treatment for an acute abdomen was. It was NG tube insertion and often surgery. He then laid out what the failure to diagnose and treat an acute abdomen looks like. It results in worsening distension, bowel infarction, sepsis, cardiac arrest, and death, which is the same course that Mr. Lacaraza took. Dr. Drew was critical of each of these defendants until the last two, PA Darling and Dr. Quadri, for failing to recognize and appreciate signs and symptoms of an acute abdomen and placing an NG tube and ordering the surgical or GI consult. That is the very treatment he says is appropriate for that condition, NG tube and likely surgery, which is why he needed a surgery and or GI consult as opposed to any other consult, which should not be considered to suggest that they conform with the standard of care by performing various other consults. As to PA Darling and Dr. Quadri specifically, they, after receiving calls from the nursing staff of critical lab values, which are contained at Record Appendix 1, page 192, decreased urine output, and a difficulty maintaining IV access, they failed to assess him completely, never went to see the patient, failed to input a central line, and failed to order the transfer to the ICU. Dr. Drew's letter specifically states that had these defendants actually assessed Mr. Lacaraza at bedside, they more likely than not would have diagnosed his acute abdomen and would have treated it as early as 1/17/14, the evening before he became unresponsive. The signs and symptoms of the acute abdomen during that overnight shift included distended and firm abdomen, as well as indigestion and loose stool. These symptoms hadn't gone away. I would refer your honors to Record Appendix 1, page 110 to 111, which document the findings that overnight shift. We certainly can't assume at this stage that had the defendants actually assessed him, which they should have done according to Dr. Drew, they then would have been negligent. That would be a reading, that would not be a reading of this offer of proof in the light most favorable to the plaintiff. The expert's opinion is clear that more likely than not, he would not have suffered a bowel infarction. He would have avoided that catastrophic consequence, and he would have survived.
Counsel, the time is very short. I just have one global question, and that is, to what extent do you think this case exhibits a flaw in the tribunal scheme? And by that, I mean, is it unreasonable to ask a medical expert to sit on a tribunal, bringing his or her medical expertise to the fore without any JD impairment, and ask that person not to evaluate the strength of the evidence?
Well, Your Honor, to that I would suggest that there is certainly an important purpose for the physicians sitting on the tribunal. And I agree with you in that they do need to assess it with that expertise in mind. But I would suggest that the things that were brought up by the medical member in this particular tribunal, given that I was there arguing it, were just questions that had nothing to do with the sufficiency of the offer of proof, such as whether Dr. Pham was the patient's usual nephrologist, or whether the plaintiff sued the surgeon, or whether we included the preoperative evaluation in the offer of proof and why not. So I would suggest, well, Your Honor, I certainly believe that there is an important role that the physician plays in informing the judge and the attorney on the panel as to the medical conditions. I would suggest at this point, the plaintiff has the appropriate evidence to go forward from Dr.
I think we should leave it there. Thank you, counsel. I gather, Mr. Keefe, you were going to argue first?
Yes, Your Honor, if I may. Members of the panel, may it please the court. My name is Michael Keefe, and I represent Trent Hiles in this matter. As Attorney Golowski pointed out, Mr. Hiles is a physician's assistant. He practiced with an orthopedic surgeon down in the Brockton area, and he provided orthopedic coverage for Mr. La Carraza following his hip replacement surgery. Now, the record shows that Mr. Hiles rounded on the patient on January 14 and 15. The plaintiff makes no allegations with respect to those encounters. The plaintiff alleges that Mr. Hiles was negligent and departed from the standard of care on the 16th, the 17th, and the 18th, when he failed to recognize the signs and symptoms of an acute abdominal process and failed to act in response. Respectfully submit that the tribunal got it right and judgment properly entered for Mr. Hiles, since there is no factual support rooted in the medical record for the opinions expressed by the expert, Dr. Drew, with respect to Mr. Hiles. And Dr. Drew.
Can you be more specific on that?
Sure. Thank you, Your Honor. I appreciate that.
Given you only have a minute and 30 seconds.
I'll get right to it. Yeah, I'll get right to it. So if we look at the record on January 16, well, first of all, the signs and symptoms, as was cited by the expert, you're familiar with them. They're at the expert's letter at page 220. If you look at the record appendix for page 65, that's the January 16 encounter with Mr. Hiles. And the only complaint made to Mr. Hiles was indigestion. And that note was dictated, if you look at page 65, at 2:16 in the afternoon. There's been some discussion of a nurse's note that appears at page 109. However, my reading of that note as it appears in the record is it's timed 5:29. So whatever was written in that note was not available to PA Hiles as of his encounter with the patient earlier in the day. If we look to the 17th, and the note pertaining to Hiles' involvement is at page 66, there were problems related to urine and a high creatinine and other issues related to the kidney. However, there was no suggestion to Mr. Hiles that there was any sort of abdominal issue going on. There was no complaint. There was no finding. Mr. Hiles.
No, but let's go back to that same entry that you were talking about a moment ago from 5:29 on the evening of the 16th. Right? So by the time of the 17th, he's aware that there is distended and firm abdomen and diarrhea, right?
Well, Your Honor, there's been no evidence, and there's no opinion in the record that note was available to Mr. Hiles as of his encounter with the patient the next day.
Why wouldn't it be? Why isn't that a fair inference?
Your Honor, it's not supported by the expert testimony. It's not referenced by Dr. Drew.
Isn't that a fair inference that the person in charge of the care of the patient would look at the records of the nurse who has seen the patient the prior day?
Well, Your Honor, this is a complicated presentation on the 17th, and there were kidney issues.
You would think that the PA would want as much information as possible, including looking at the notes of the nurse treating the patient.
Well, Your Honor, that certainly is an inference that one might draw. I would suggest that it's an unreasonable inference in the setting of a tribunal where it's not supported by the expert opinion.
All right. Thank you, Mr. Keefe. I guess we have Attorney Weigand is next.
Yes, thank you, Your Honor. On behalf of Dr. Pham, there was no error by the Superior Court as the offer of proof was insufficient, really for three fundamental reasons. The expert did not address the standard of care applicable to the limited role of a nephrology consult. The expert letter did not in any way reveal or demonstrate any knowledge on the part of the expert that he was familiar with the standard of care applicable to Dr. Pham and his limited role. And also, we believe the opinion was based on assumption of facts that were not known or in the record at the time of Dr. Pham's consult.
Didn't Dr. Drew raise concerns about what Dr. Pham did not do? Did not order imaging, for example, based on what could have been known at the time?
Well, as far as imaging, he did order imaging. If you look at his note, he ordered a CT scan, and he ordered him to be transferred to the ICU. So that aspect of the critique, I think, is problematic. Dr. Pham, again, was not attending. He was asked to consult as a nephrologist. This man was born with one kidney. He had chronic kidney disease. and he was asked to look at what was clear to him or what was being demonstrated as renal failure. The expert says nothing about the standard of care applicable to a nephrology consult in such circumstances. He provides no basis for him to have any knowledge as to the standard of care. He makes no distinction among the defendants or addresses the specific role or consult. This is not an unreasonable burden, even at the tribunal stage. And in fact, this court in many other decisions has made that distinction. And I would refer to the McKenzie case, the Howell case, the Castrochini case, and the Jennison case, all cited in my brief on behalf of Dr. Pham. In those cases, this court upheld the finding that those offer of proof were insufficient because as to the particular provider at issue, there was no differentiation from attendings or others. And that's exactly what happened here. And it's not an onerous burden. It can be easily done, and it was not. As to the other deficiency is that it did assume facts that were not in evidence. Again, as you understand, it was the gravamen of the action is the failure to recognize signs and symptoms of abdominal process. At the time of Dr. Pham's consultation, you see his findings. Many of the things that they say he presented with were not present at that time. The fact that he had some indigestion the day before doesn't mean he had indigestion at the time of Dr. Pham's consultation, which was at 2 o'clock in the afternoon on the 17th. And based on his own examination, there was no loose stools, no diarrhea, no vomiting, no nausea, no indigestion. And this was consistent with Dr. Patel's own examination 4.5 hours later. Now, while there's some reference to the nursing notes, I would repeat what Mr. O'Keefe has said, is that there's no indication that that was available to Dr. Pham at the time of consult. I would refer to you to the note closest in time, the nursing note, which was at 7:30 a.m. I think that's at 109 of the record appendix that morning. But it's not recorded in the record until 15:29, which is in the afternoon, which is after Dr. Pham's examination. And the notes say the gastrointestinal was within normal limits and the abdomen was soft but not tender. So again, as this court has held, I think in the Cooper case, you can't assume facts that are not rooted in the evidence. And I would tell you that it's been exasperated here on behalf of Dr. Pham in the failure to identify and apply the standard of care applicable to the specific role, the limited role that he had as a nephrologist asked to look at kidney function.
Thank you, Mr. Weigand.
So that's the heart of the position on behalf of Dr. Pham, and I'd otherwise, leave the remainder to my brief.
Okay. For counsel for Defendant Patel.
Yes, may it please the court. Kelly Smith for Dr. Vishal Patel. Similarly, this offer of proof was deficient for several reasons, in particular with respect to the standard of care, because there's nothing in that offer of proof. And in particular, the expert letter of Dr. Drew and his CV to suggest that he was knowledgeable as to the standard of care as to Dr. Patel, who was, yes, board certified in internal medicine, but he had subspecialties in critical care medicine, and his role at this time was as a critical care medicine provider. He also had a limited role. He was asked solely to determine whether or not this patient had to be transferred to ICU or could be appropriately monitored on the floor. And he did a thorough examination. His consultation note is in Record Appendix 1 at pages 70 to 73. There are certain faults about Dr. Drew's opinion with respect to Dr. Patel. He makes assumptions that are not rooted in the evidence, and I will get to those. In particular, Dr. Drew fails to consider the actual results of the examination by Dr. Patel, which was on January 17, 2014 at about 5:30 in the evening, and also doesn't consider the treatment plan. Particularly, what Dr. Drew does is he makes an assumption that my client's examination was flawed because he did not find that the patient had abdominal distension or that his abdomen was not soft. That is not the case, and you cannot make those assumptions. You have to rely on the medical chart. And that's the flaw here, is that Dr. Drew is making assumptions without support in the chart. The chart.
I thought there were indications in the nursing records of distended and firm tender bowels.
Thank you, Your Honor. So the closest nursing note, and I want to bring that to the attention of the panel, is that there's a 5 o'clock note by a nurse. It's an addendum, and she in there indicates that under findings, the abdomen is soft, it's not distended, and there are positive bowel signs, and no nausea and vomiting. Also,
but there were other notes that were inconsistent with that, weren't there?
Earlier notes, yes, the day
Right,
before,
right.
yes.
But I mean, so there is some inconsistency, to the extent that there is inconsistency in the medical history that's available to the treating physician. Isn't that something to sort out?
There's no inconsistency. It's just a change in the patient's presentation. That by the time Dr. Patel takes a look at the patient's improved. He's doing, I mean, yes, he has increased shortness of breath. He has some tachypnea, but you know what? He tells Dr. Patel, you know what? I don't have that heartburn anymore. I don't have that digestion. And in support also of Dr. Patel's findings is the findings by Dr. Fernandez. And if you look at her note, which is at 8:03 a.m., page 77 in the record appendix, she also does an exam, and she also finds that the abdomen is soft, non-tender, and non-distended. But also, so we have those issues, but what Dr. Drew also fails to recognize is the treatment plan that was put in place by Dr. Patel. He orders the CAT scan. It shows that an order is entered at 5:29. Dr. Patel wants to recognize, he appreciates that the patient had some indigestion, some heartburn, some nausea the day before. And he says in his note, the etiology is unclear. I'm going to order a CAT scan. He orders the CAT scan. So contrary, Dr. Drew's opinion that it should have been done emergently. Well, it was done. And another error, according to Dr. Drew, is that we didn't follow up. Well, Dr. Drew doesn't recognize that my client went off service, but the CT was reviewed. It was reviewed by Dr. Fernandez 2 hours after it was done. And nothing differently had been done. There's this causation piece.
Okay, thank you. I understand. I understand your frustration. We will and have done thorough. We've been more silent than usual because we realize that you all have a lot to cover. Attorney Bruce.
Good afternoon, members of the panel. May it please the court. It is my pleasure to argue on behalf of Physician Assistant Darling, Dr. Quadri, and Dr. Fernandez. I would like to simply get right to the heart of my argument. I am not arguing on behalf of my 3 clients that there are issues of fact in dispute. I think at this stage of the proceedings, that argument is not particularly productive. What I am arguing is that there is an absence of facts to support a couple of key parts of the plaintiff expert Dr. Drew's opinions. The first one pertains to Dr. Drew's qualifications. His curriculum vitae is attached to the record appendix at page 224, 225. What is absent, not in dispute, what is absent is the statement that Dr. Drew is familiar what internal medicine physicians of the subspecialty of hospitalist medicine would do. If we conceive of this from a directed verdict standard, as if we were in the courtroom in front of a jury, listening to Dr. Drew's testimony, the statement he admittedly includes in his written opinion is not sufficient. If he was pressed on the point, Dr. Drew would be required to say he has some familiarity with what hospitalists and other subspecialists in internal medicine do from whatever source. Now, that testimony would allow the court to accept Dr. Drew's opinion, but that information or evidence is absent from the offer of proof. There's nothing in the written opinion of Dr. Drew or his curriculum vitae that would substantiate any knowledge or experience that he has as to what a hospitalist medicine physician would do. My second argument pertains only to the causation aspect of Dr. Drew's opinion. He admittedly provides a blanket opinion that had the defendants done something different, Mr. La Carraza would not have developed a bowel infarction, cardiac arrest, or ultimately passed away. What he doesn't say is at what point any of these things would have made a difference. So to put it in terminology required for the offer of proof in the tribunal, Dr. Drew fails to substantiate a legitimate question that even if the defendants had done what he claims they should have, it would have made any difference. For example, there's no statement of Dr. Drew as to what point the bowel infarction began, or more importantly, at what point his bowel became non-salvageable, meaning the necrosis and damage progressed to the point where surgery could not have saved his life.
Doesn't that go to the weight?
I'm sorry, Your Honor?
Sounds like that this is at the gating issue. I mean, it sounds like you're arguing things that go to the weight of it. Why is this a pure, you don't make it past go?
Those are certainly, I'm sorry to interrupt. Those are certainly arguments that are made as to the weight of the evidence and during a trial. But my argument today is that Dr. Drew is nonetheless required to put something in his opinion that establishes causation between any of his criticisms of my clients and the injuries Mr. La Carraza ultimately experiences.
Counsel, to sum it up, you're essentially saying his conclusion is too conclusory.
Yes, and requires some facts to support it.
All right. Thank you all. Again, we realize that this case is very factually intensive. We will conduct a thorough review, and we appreciate your arguments. They've been helpful. That concludes our session. I again want to thank our session clerk, Patricia Ryle, has done just an extraordinary job helping us through this virtual hearing today. And again, remember our lost leader and friend, Chief Justice Ryle.